All right, good morning, everyone. Wednesday, February 13th, my sister's birthday. It's 9:30 a.m. and we are going through our OPR bill with Legislative Council. We have both Tucker Anderson and Tim Devlin here. Good morning, gentlemen. How are you? Well, cool. Please, sir, yes, join us. Enlighten us with words.
Sounds like a spell I would be casting. Enlightening words.
Sorcery.
Well, good morning, Tucker Anderson, Legislative Council.
Tim Devlin, Legislative Council.
And we decided to tag team this morning because, as you know, I worked on this issue in Tim's absence, but Tim is back now. So as Tim gets back into the flow of things, we might do a few of these side by sides for your appreciation. So you have in front of you a draft of request 250244. This is draft 1.1, and this is the miscellaneous amendments to law professions and occupations, sometimes referred to as the miscellaneous OPR bill. You have already received an overview explanation of the contents of this draft from the office itself. So we will be doing a walkthrough of the words on the page and fielding any questions you have about the underlying law to the best of our ability at this time. Section 1 proposes amendments to 3 VSA, Section 122, relating to the Office of Professional Regulation and the professions that are regulated. And the amendment that takes place in Section 1 is on page 2, line 4, which repeals motor vehicle racing from the list of regulated professions. There is a conforming repeal at the end of the bill, which repeals the entirety of the subchapter governing motor vehicle racing. Any questions about that?
Racetracks. Anyone?
We are all set on
Very
racetracks.
good, yeah.
Thank you.
Okay. I know that there was at least one outstanding question about the regulation of this particular field once that subchapter is repealed. And to frame the question, it was whether there was any other regulatory framework that governed motor vehicle racing. Particularly some of the ad hoc events that are described in that subchapter, such as demolition derbies. And the answer is that in Vermont law, there is no other statute that would govern those sorts of events, requiring, for example, the inspection of the track where it's taking place or the vehicles themselves. It would fall under Title 23 only in an instance where those vehicles were also street legal vehicles that were being used for the purpose of conveying on highways of the state. So that is the response to the question. Section 2, there's going to be 2 amendments here. First, 3 VSA section 123. In subdivision K2, there is an elimination, strike through, of a reference to pulling the pre-application fee from the license application fee itself. You heard some testimony about this the first time that you brought up this bill. But it strikes through language that states that if an individual applies for licensure, the pre-application fee shall be deducted from the license application fee. We're moving on to page 3, line 1, subsection M of the same section states that the provisions of subsection 116A sub B of this title, we're still in Title 3, shall not apply to the office. And that subsection relates to the periodic review of boards and commissions for potential repeal. This subsection M goes on to state that the office shall utilize the procedures within Chapter 57, the offices chapter, to review whether regulation of a profession is still necessary. So altogether, what this new subsection does, it states that there will no longer be periodic 5-year review of the boards and commissions within the office to determine whether they need to be repealed. In lieu of that, the office will conduct an internal review to determine whether or not a board or commission within the office is still necessary. And you'll be familiar with this because of the work the committee does in this periodic review with repealing boards and commissions. Section 3, quite a bit of fees in this section in the underlying law, and there are a handful of amendments proposed. 3 VSA section 125, proposed amendments. First, in subsection A in subdivision 1, an increase of the fee for verification of a license from $20 to $30. Moving on, in subsection B, in subdivision 4, a new biennial fee specifically for electrology shops in the proposed subdivision capital W of $200 biennially for electrology shops. Moving to the end of subsection B, a series of newly proposed fees. First, in subdivision 9, for apprenticeship applications, a proposed $50 fee. In subdivision 10, specialty endorsements for existing licenses. The application fee there will be $100. The committee is likely most familiar with the specialty endorsements that have been proposed in the past for notaries public. Data feed annual fee, $1,500. And in subdivision 12, a disciplinary action surcharge of $250. And we'll get to language later on where the application of that disciplinary action surcharge comes into play. Moving on to page 4, we are still in that fee section, and there is a proposed repeal of subsection C. Current law that states that notwithstanding any provision of law to the contrary, a board shall not require payment of renewal fees for years during which a license was lapsed. So, applicant allows a license to lapse for a period of years, returns after those years to renew their license. This subsection C currently would prevent the board, the regulatory board, from collecting fees for the years that have lapsed. This repeals this subsection, but I will say that, in my opinion, might need to do more research on this. If the intent is to allow or expressly authorize a board to collect fees for lapsed years, this repeal might not get there. You might need to grant the express authority to collect fees for lapsed years.
And that's only if the individual was practicing during those years of a lapsed license.
And renews after those lapsed years.
Is there never mind.
Yeah, no, that's something we need to understand more clearly, for sure. So, just as to like the current practice, how those will impact, like, we'll ask more questions with those across the street. Representative Uber.
This is not to be confused with if your license is suspended.
Correct. This is, you have gone inactive by virtue of not applying for renewal. In section 4, Tucker Time Machine has come up quite a bit this session, and we are back in the Tucker Time Machine. And that is because section 4 is in the same section as section 3, but as you will see in the effective dates, it is taking place in the future, specifically in the year 2027. Tim gave me a modest confirmation. And this is a proposed increase to the fee or biennial renewal of peer support provider or peer recovery support specialists from $50 to $75, and that increase will take place in 2 years. In whatever the committee works on for a subsequent draft, I will make sure to put in a reader assistance heading that marks this as a prospective increase for the year 2027.
Appreciate that.
Do you want to roll?
No,
Okay. Section 5 proposes amendments to 3 VSA section 127, which governs unauthorized practice. In subdivision B2A, there is a proposed increase of a civil penalty under this section from $2,500 to $5,000. This can be brought by the Attorney General or by an attorney assigned by the office.
I'm sorry, what, oh, sorry, I got it.
Gotcha.
It does conform to the amounts of some of the other civil penalties that are outlined in that section. You'll
Nope.
note that in the preceding subdivision, it is also $5,000. In section 6, previous A section 129 is amended related to the disciplinary process. In subdivision A3, this is the subdivision governing the issuance of warnings, reprimands, and suspensions. We're moving on to the top of page 6. The amendment can be found starting on line 3. After a finding of unprofessional conduct, a respondent shall pay a disciplinary action surcharge pursuant to subdivision 125B12 of this title. As you recall, that is the new $250 surcharge that's proposed. Proceeds from the disciplinary action surcharge shall be deposited into the professional regulatory fee fund, which is the special fund that all of the regulatory fees go into to support operation of PR.
what's fine.
It is, yes. Although fines, so Representative Hooper said, so it's a fine. It would not be a fine because fines are criminal penalties. This would fall in line with a civil money penalty, but is expressed here as a fee or surcharge that is applicable to a licensee who has been found to have conducted unprofessional conduct.
Then the fund is just the financial support for the operations of the office itself to staff to engage in matters.
It is not my testimony, but there was testimony from, I believe, the Deputy Secretary of State specifically about the costs of prosecuting some of these unprofessional conduct cases. And the committee often, when looking at fees, attempts to compare what the fee is and what the cost of administration around a particular license or fee is. Just for context. In section 7, there is a proposed amendment to 26 VSA section 281. And this is, the committee was briefed on this. These are updates to the cosmetology licensure requirements. So in subdivision A4 of that 6 VSA section 281, the new requirements require training on the care, styling, and treatment of textured hair. Textured hair is defined as hair that is coiled, curly, or wavy. We have moved on to the top of page 7. The training shall include, in subdivision A, techniques for cutting, styling, and chemical treatments for textured hair. In sub B, knowledge of products and tools specifically designed for textured hair. Sub C, best practices for hair health and scalp care for clients with textured hair. And finally, in sub D, cultural competency and historical education on the significance of textured hair in diverse communities. So educational requirements to maintain licensure for cosmetology.
Questions on that one?
Diversity.
I mean, it's like you train on a bunch of different things, yeah, you know, it makes sense. Okay.
Section 8, you have reached the final substantive proposal contained within the miscellaneous OPR bill. In Section 8, there's a proposed amendment to 26 VSA, Section 1272, that relates to the escrow accounts and escrow agents required for prepaid funeral funds. In Section 1272, this requires the director of OPR to adopt rules relating to the appointment of an escrow agent who may be a bank or other category of individual, such as an attorney. Love that. Or the executor of a buyer's estate, and that all prepaid arranged funds shall be paid directly to the escrow agent and not to the funeral director or establishment. So you have a third party who's acting as a fiduciary to maintain an escrow fund for prepaid funeral expenses. That is being repealed. The requirement for the adoption of rules governing this practice.
So if you already have it set up at the funeral home and this is being repealed, so we have to do alternatives?
So the repeal of the legal requirement for the use of an escrow agent in this case does not in itself extinguish any existing relationships where an escrow fund has been set up and an escrow agent has been appointed.
Going forward, though, that would eliminate funeral homes.
It would eliminate the need to designate an escrow agent for these types of funds.
Gotcha.
Still do it. Just
Yeah.
There is a conforming repeal in section 9 that repeals the section describing the duties of escrow agents in this context. That's 26 VSA section 1275. And then you'll note in sub B of section 9 that the motor vehicle racing chapter is repealed. In section 10, you have staggered effective dates. Every section of the act, including the effective date, takes effect on July 1st, 2025, except for section 4, which was the one fee increase that is delayed until July 1st, 2027. And that was the peer support specialist fee. Okay. And that is all.
Any questions for these gentlemen while we have them here? So we gotta need more testimony on that lapsed fee conversation. I got that flag. Did you flag any pieces?
I did. I actually have in my head here, just wondering how many more hours are going to be required of a cosmetology barbering student to incorporate these new regulations. So that'll be for OPR. 'Cause
Or
that'll
we
be
should
a
find somebody who like represents the
consideration.
barber cosmetology folks and maybe check some of them on the training side.
That's
Right,
good.
Representative Morgan.
just off the top of your head, if it's a fair question, guys, do you know what percentage overall for hikes, fee hikes here we're looking at? Is it, or is that too broad of a question?
It is not too broad. It is sufficiently specific. I just wouldn't know. There are quite a few subdivisions. You'll
Right.
note that in one instance, we were down to subdivision number,
Right.
capital W.
Yeah,
And that is just one subdivision out of, I believe, 6 or 7. But
I'm just curious if
do
there's,
that math for you. I just have to pull up the statute later, so I'll circle back.
just curious across the spectrum, what that overall height might be, just percentage wise. Okay, thank you.
Any other questions for these, John? All right. We'll go through the notes that we've taken collaboratively and start pulling some more folks in the chat about this. So any feedback, thank you. Any feedback from any of you folks on somebody you might want to talk to as we look at this, it's greatly appreciated. Last call for questions for Ledge Council.
Can I just ask a question about the fees since Rep. Morgan brought that up? I'm getting like a ballpark figure of $395 in increased fees and then increased or new fees. But then I did not take into account this new data feed annual fee because that's something we don't know a whole lot about. So that's $1,500 that doesn't currently exist in the structure. And then the Attorney General's fine for unauthorized practice going up $2,500, which I don't really consider a fee. I consider that a payment for wrongdoing. And then
So we're talking-
another surcharge of $250 on top of that $395. So that's kind of the ballpark we're looking at. We've got $395, $250, $1,500, and another $2,500.
So I talked to AG about that. 25.
I'm fine with that section. I think it's the increased fees that Rep. Morgan
Yep.
is concerned for.
My
So
concern is, the
couldn't do
death
the
by,
math fast enough.
the death by 1,000 cuts. You want to make sure
Oh,
we're
no.
not totally, because one thing I think that we as a group get beat up on is you're killing me, so
No,
I'm
no,
just
no.
trying to be
I know.
mindful of that and make sure we're not killing it.
No, I'm very sympathetic to that as well. I mean, I have notes here also that we check in with the administration's legislative affairs team and get a sense of where their heads are at with
Yep.
this, because
It's a component of the budget
Yeah.
in an indirect
we need
fashion.
to have a mutual understanding of whether or not these things are agreeable before we start moving this thing out of the room.
Makes it go smoother.
Doesn't it?
So that's all. I'm just being mindful of that. I guess is the.
I appreciate that. Anyone else? Okay, thank you so kindly. So we're gonna have a little bit of time here before our next block of testimony, 10:30. That'll give us some time to like chit chat about a few of these items and the piece got, so H44. The DUI bill we spoke about yesterday. Chair Lalone checked with Commissioner Morrison, she's fine with the task force. But it appears the Sheriff's Association wants to talk to us about it. Luckily, Sheriff Anderson's in the building today anyway. I was just texting with him, so we're gonna have him come in and speak to his thoughts
Right now.
soonish. I wanna chat with him first, just to understand where his head's at. And then we asked a lot to speak to Ledge Council, to Negroski. He has to get here too, because if we have to move a couple of words or add a couple of words, he needs to be in the room with us. So that's gonna be plugged in, and we left a couple of little gaps in today, knowing there were some moving parts, so he's probably gonna, that conversation is gonna plug into one of our gaps, so just a heads up. But if Sheriff Anderson does want to include something, I don't think it's notable. It's not a shocking conversation, I don't think.
Yeah.
So I'm gonna go track him down. Autumn, could you take us off, please?